Why didn't I get an abstract of title with my recent farm purchase? Should I be freaking out? Is this something I need to track down now? Do I even own my farm? Hi, I'm the farm lawyer. We get this question a lot after a real estate closing and if there's not an abstract of title involved. Let's break it down. Traditionally, in states like Minnesota and throughout the Midwest, abstracts of title were the gold standard when it came to real estate closings. We have farmers that come into our office with stacks of abstracts. This is what shows the farm that you own. You remember that you got it. You can look back into it and see who owned it before you. You can look at the history of title, which is exactly what an abstract is. It's just a chain of title that goes back all the way until the time that property became part of the record system of the United States. Usually you see an early entry from, Abraham Lincoln signing a patent that this land exists. So these are big, thick, legal-sized paper books that just show the chain of title. Who owned it before you? Who owned it before that? Did they get a mortgage? Is there an easement? But it also is important when we're examining title that we can follow that chain, that we make sure that if there's any mortgages, that they've been released, if there's any easements, that we know about them. Of course, we have to remember that it's a record of the chain of title, which means that if there's an unrecorded easement, by definition, it's not going to be in the chain of title. It could be entered at a later point in time after you purchase, which we wouldn't know about if we look at the abstract because it's not recorded. So this abstract shows us what is in the public records, the property records for a particular piece of property. The abstract needs to be certified to the property that you're purchasing or selling in entirety. So if there's a piece of it that you added later on, or you sold off a piece of the property, it may be that that abstract is no longer certified to the property that we're actually looking at now. So we need to know that first. Is this abstract even the right abstract for the property we're looking at? Or maybe it's part of it, or maybe it's more than we need, but is it the right one? Then we look at, when was it last updated? A lot of abstracts are not updated at all anymore. Reason being, internet, right? So with how property records are kept now, we still use the abstract system. It still goes into public records, but unlike in the past, where those public records really only existed in the courthouse or the property records office, now with online access, we can search up property records for specific pieces of property and get the whole records from that property from sitting at my desk. Now, of course, we pay a subscription for that. There's a user fee. We have to sign up with the county, but that is the way that we search records most of the time in our office. It certainly helps to have an abstract because those records are only indexed often through the late 80s or early 90s. And that's not a long enough time period for us to do a full title search. So then we either have to pull other records directly from the county or start looking in other indexes. But if we have the abstract there, that can help us bridge the gap. But it doesn't mean that we necessarily need to update that abstract. So why didn't you get an abstract at closing? Well, because they're getting phased out, because we have online property records. Title insurance is also a big reason. So I gave that example of that unrecorded easement. An abstract of title and a title exam is not going to give you any protection at all against an unrecorded easement. Title insurance could. So it's becoming much more common, especially if you're getting a loan. Most lenders these days are going to require title insurance. So if we're doing it for the bank, oftentimes the title insurance would be done for the buyer at the same time. Another big reason, at least in Minnesota, is that abstractors are becoming rarer. There are a lot of places that if you don't already have an abstract, they will not create a new one. They might give you what they call a stub abstract, which could be a 40-year search, but they're not going to go all the way back to the 1800s. The other thing is, updating an abstract is just an additional cost to what we're already doing. We're doing the title exam, either an opinion or a title insurance. So if we're adding a updated abstract on top of it, it can just add another expense. Now, if your seller has an abstract, definitely you want that. But if you did not receive one, you should not be freaking out. Just because you don't have an abstract doesn't mean you don't own the property. It doesn't mean you don't have proof that you own the property. Your proof of that is in the deed that you received at closing or shortly after closing. And most importantly, it's the property records that exist at the property records office in your county, which is what the abstract reflected all along anyways. Now we can get that through online access to property records. So if you didn't get an abstract, it's not a huge deal. It's very common that we don't get abstracts anymore. If you went into a new housing development, for example, they're not creating abstracts for each parcel that exists out there. They're all getting title insurance or some other search. They're not getting an abstract of title. They're not even being created for those properties. But for your rural properties, if you're able to locate an abstract, hold on to it. You just don't necessarily need to get it updated. For more tips on farm law, follow me. I'm the Farm Lawyer. Hit the subscribe button. Drop a comment below if you got an abstract with your last purchase.